Hi, thank you. Good afternoon or good morning, depending on where you are today. I know that we have people tuning in from across the country. I'm in Washington, D.C., where it is the afternoon here. It's a pleasure to be here with you today. Thank you for having me, and thank you for all of the important work that you are doing in your communities. And congratulations to all of you, whether it's your first time receiving a federal grant or whether you've been doing it for years now. It's certainly a success for your organization. Today we have a 1.5 hour block, so we're going to be dividing that up. We'll go through slides together for about 45 minutes. We'll then have a 10-minute break, and then we'll resume with about 35 minutes left in the presentation. We're going to be covering a lot of material today that we hope will be helpful and useful for you. And this PowerPoint presentation will be made available for you. So we hope that this will serve as a handy reference for you. There is no need to try to memorize all of this information, but the slides will be available for you, and they contain many links to helpful resources that are available online from my office and from other organizations as well that will help you as you come into compliance and remain in compliance with civil rights laws. With that, also to let you know, my office is always available, and all of our contact information is available in this PowerPoint presentation. We can be contacted by phone, via email, or through our website. And with that, we'll get started. Thank you. First, of course, lawyers are known for giving legal disclaimers. We do just need to let you know that this presentation is not legal advice. So as you'll hear today, many situations are very fact specific. We need to observe them and analyze them on a case-by-case basis. So please feel free to get in touch with us with any specific questions, or we are taking questions at the end of the presentation. I would be happy to answer your questions as well. In the event that we don't have time to take them at the end of the presentation, I will certainly follow up and answer any questions that you have. And as I said, our office is always available to answer questions and offer assistance, and we are happy to do that. So I'm an attorney in the Office for Civil Rights. We are a component of the Office of Justice programs that falls under the umbrella of the United States Department of Justice. The main thing for you to understand about OJP, the Office of Justice programs, is that it gives out grants. So there is a lot of money that is going out from OJP to lots of different types of organizations and entities all across the country. And the Office for Civil Rights, my office, is responsible for making sure that any recipient of funds from the OJP, from the Office on Violence Against Women, known as OVW, and from the Office on Community-Oriented Policing Services, known as the COPS Office, that all of these entities comply with federal civil rights laws that apply to them. So the goal is that today you'll understand an overview of the civil rights laws that my office enforces, and importantly, how they may apply to the work of your organization now that you receive federal funds. So one way to think of our office is that the OCR, the Office for Civil Rights, is essentially the civil rights strings that come with the money that you have received. Sometimes our office is confused with the Civil Rights Division, which is also part of the United States Department of Justice. But for us, for the Office for Civil Rights, our authority is tied to money. So the main thing for you to take away from this is that whenever there is federal funding involved, there are always civil rights requirements that accompany that funding. The underlying principle here is that because federal funds come from taxpayer money, everybody is paying into this pool. So everyone pays taxes, people from members of all different groups. And so it would be unfair for that same money to then be used to discriminate against one of these groups. So that's the principle that we're operating on here. And I just want to make sure that we have a clear understanding about two key terms when we're talking about federal financial assistance. The first is a recipient, and the second is a beneficiary. A recipient is an organization or agency that receives federal financial assistance. So that includes state administering agencies, which you may hear referred to as SAAs, state and local courts, law enforcement agencies, departments of corrections and jails, nonprofit agencies, educational institutions, faith-based organizations, and many other service providers. That was recipient. And for beneficiary, this is the individual who ultimately receives the federally funded services or benefits. So that may include participants in programs such as young adults who attend federally funded after-school activities. It may include survivors of domestic violence who seek the services of a funded shelter. And one might also think of beneficiaries more broadly as the people in a community served by a funded law enforcement agency. Recipients may often refer to beneficiaries as their clients or customers. So again, a recipient is the entity that receives the money, and the beneficiary is the one that benefits from the program or service. This slide is a listing of everything that my office, the Office for Civil Rights, enforces. Except for that last bullet, all of them are what are known as federal cross-cutting civil rights statutes. What it means that these are cross-cutting is that they apply to all recipients of federal financial assistance, regardless of the federal agency that is the source of the funding. So everyone here today has received funding from the Department of Justice, but all of these statutes, except for that last bullet, apply to recipients of federal funds from all agencies. So DOJ enforces them, and so do other federal agencies. We'll go through those first, and we're going to get into detail with all of these later on in the presentation. But just to give you a brief overview, there's Title VI of the Civil Rights Act of 1964, which covers race, color, and national origin. There's Section 504 of the Rehabilitation Act of 1973, which covers disability. There's Title II of the Americans with Disabilities Act of 1990, the Age Discrimination Act of 1975, and Title IX of the Education Amendments of 1972, which relates to sex discrimination in educational programs or activities. Those are what we refer to as the cross-cutting civil rights statutes. The last bullet you'll see here are referred to as non-discrimination provisions, and these are program statutes. So this last bullet is DOJ specific. Only DOJ refers to these and uses them to enforce civil rights laws. They are the Victims of Crime Act, known as VOCA, the Omnibus Crime Control and Safe Streets Act, known as the Safe Streets Act, the Juvenile Justice and Delinquency Prevention Act of 1974, known as the JJDPA, and the Violence Against Women Act, known as VAWA. Sorry about that. I had a technical glitch there. This listing will see protected classes. So I'll first read them through so we can go through them together, and then we'll talk about the significance of what they mean. So the protected classes are race, color, which includes intraracial discrimination. So that differs with race because people can be of the same race, but treated differently, literally because of the color of their skin. That's why color is a separate category than race. There's national origin, which includes limited English proficiency that we'll get into in depth, as with all of these classes. There's religion. There is sex, that includes sexual harassment, disability, and age. And for VAWA only, there is also sexual orientation and gender identity that are actually considered interpretations of the category of sex. The important thing to understand about protected classes is that a protected class is a group of people who benefit from protection by law. And when a person brings a discrimination claim under a federal civil rights law, it is actually not about how that person has been treated as an individual. It is actually because that person is a member of a particular group. And being a member of that group has caused that person to be denied certain rights. So that's why it's important to look at protected classes and understand protected classes. Additionally, the Office for Civil Rights looks at retaliation as something that is separate than any underlying discrimination. So any retaliation, which may include harassment, demotion, discharge, or denial of services, is actually something that we would consider on its own. Meaning, if someone was discriminated against and reported it, for example, and then experienced retaliation because of the fact that they reported it, we could follow up on a retaliation claim, even if we couldn't prove the underlying discrimination. So retaliation is considered almost like a separate category of its own. And we're moving on to the next slide here. To look at who is subject to these laws, we're going to go into more detail about the statutes and provisions, but it's important to have a fundamental understanding that in terms of a program or activity that receives financial assistance from the DOJ, all operations of an organization that receive federal financial assistance are covered. And so if one part of the organization receives the money, the entire organization is covered in terms of its requirement to comply with prescribed civil rights obligations. Looking a little bit more closely at how my office actually goes about enforcing civil rights laws, we provide technical assistance. We would consider this presentation today to be an example of that. And we also will just follow up, as I mentioned, on any way that you would like to contact us by email, phone, or through on-site training. We provide technical assistance to follow up on individual questions. We're happy to do presentations for individual organizations as well. The main thing that we do, sort of the bread and butter of our office, is our administrative complaint investigations. So we accept and investigate administrative complaints from both employees and beneficiaries of those that receive DOJ financial assistance. The employees of the recipients and subrecipients do not have to exhaust their employer's internal remedies to file a claim with us. And they don't have to wait for clearance from Equal Employment Opportunity, the EEOC, the Equal Employment Opportunity Commission, before filing with us. They can come to us directly. Any party that wants to get in touch with us does not need to retain a lawyer to file a complaint. They can simply go to our website and we'll be providing the links. They just fill out a form or get in touch with us. And we sometimes also get referrals from other parts of the Department of Justice. If there's an individual that gets in touch with them and the complaint actually belongs with us, they will route it to us as well. So it could be, a complaint could be filed by a client here, also this could be a beneficiary. So the recipient of federal funds may refer to this person as a client, or they may refer to them as someone who's participating in a program, or it might simply be a community member who is receiving the benefit. The complaint could come to us from an employee or an applicant for employment. So if someone has interviewed for a position, that would even make them able to submit a complaint, with us, or a third party even. So we often get complaints that come in from someone on behalf of their child, on behalf of another loved one. We don't have a requirement that the person, him or herself, would get in touch with us. It can be through a third party. That's particularly helpful in the context of prisons. Sometimes inmates are not able to get in touch with us, or if you there may ever be an instance where somebody would have difficulty getting in touch with us directly for any reason, we are happy to take those complaints. So in terms of the process itself, when the first thing we do is check to make sure that we have jurisdiction. And what that means is that we have authority to look at the complaint. So we need to verify that the entity that has a complaint lodged against them is in fact receiving federal funds from us. And then we can launch our investigation. Once we gather sufficient information, we evaluate the merits of the complaint. So the complainant will hear from us either way. If we find that the facts do not support the claim and we close the complaint, we will notify the complainant and we will advise them that they can pursue remedies either in federal or state court or with other agencies. When we close something, it doesn't prohibit the complainant from going on and choosing to continue with another entity. If our office finds that the facts do support a finding that a funded organization does not comply with federal civil rights laws, then we work with that recipient to explore ways in which they can come into voluntary compliance. Now, as you would imagine, we have a very high level of cooperation from recipients because everyone wants to keep the money that they've received, and they also want to be eligible for funds in the future. So we're fortunate that we oftentimes get even more compliance than lawyers who are in active litigation because, again, our authority is based on money and everyone wants to keep their money. We do put a great deal of effort into negotiating agreements with recipients and we do follow up on them. But if we can't ensure that the compliance of a recipient is in fact taking place and that civil rights laws are not being followed, then the recipient can be suspended or terminated from federal funding. And that may affect their current funding and also future funding. A note about American Indian and Alaska Native tribes. Like all other recipients, tribes incur civil rights obligations as a condition of accepting federal aid. So that does mean that funded tribes cannot discriminate against a beneficiary based on race, color, national origin, sex, religion, disability, or age. But there are clear distinctions between the civil rights obligations of American Indian and Alaska Native tribes and other recipients. So there are two important exemptions. First, tribes are not bound by the DOJ program statutes that prohibit employment discrimination. Title VI of the Civil Rights Act of 1964, which applies to both private and public employers, actually expressly exempts American Indian tribes from the law. So American Indian tribes are not subject to the prohibition against discrimination based on race, color, national origin, religion, and sex in employment specifically. Because the DOJ program statutes rely on Title VI standards in enforcing civil rights as they pertain to employment discrimination, the DOJ reads into the program statutes the same exemption applying to funded tribes. So because of this policy, tribes that receive funding from DOJ do not violate federal civil rights laws if they exercise an American Indian or Alaska Native preference in their employment practices. So to reiterate, American Indian or Alaska Native tribes that are funded may legally prefer American Indian and Alaska Native individuals in their employment and hiring practices. The second thing that's important to understand that is a way that distinguishes American Indian and Alaska Native tribes from other federal recipients are that they are also exempt from the requirement under the Safe Streets Act to prepare or submit an equal employment opportunity plan to the Office for Civil Rights. And we will get into that in more detail, but the important thing to know is that funded tribes simply need to file a certification with my office, attesting to their exemption based on their tribal status. I apologize, we have to go back one here. In terms of the American Indian and Alaska Native beneficiaries, I apologize, I think we may have skipped one slide. But you have for your reference this slide, there are two slides on American Indian and Alaska Native tribes, this one and this next one here. So as this slide states, civil rights laws apply to American Indians and Alaska Natives as protected classes based on race or national origin. And American Indians and Alaska Natives have also often relied on the protected class of religion to counter discrimination based on religious practice. It's important to note that the legal definition of American Indian for civil rights protections is not the same legal definition of American Indian for some federal entitlement programs. So, for example, if an individual brings an employment discrimination claim against an employer based on their race or national origin as an American Indian, that individual who identifies as American Indian does not need to show a percentage of ancestry or prove bloodlines or be an enrolled member of a tribe. So this person can bring a complaint that would be covered under federal law as long as the employer reasonably believed that the employee was a member of a protected class based on some objective evidence, which may consist of physical appearance, language, cultural activities, or association. Now we're going to dive a bit more deeply into the civil rights laws themselves. And we'll start off with Title VI of the Civil Rights Act of 1964. This is the significant language of Title VI. And it provides that race, color, and national origin are protected classes. regarding any program or activity that receives federal financial assistance. And one thing to note is that if you were to look at the language of other civil rights statutes, you'll notice that they are very similar to Title VI, and that's because Title VI, this statute, provides the basis that many other statutes have expanded on in terms of protected classes. So they follow Title VI language. And as many of you may be familiar, when this law was adopted in 1964, it was a very pivotal year in US civil rights history. And so the Title VI and its language are very significant. Here, this is a listing of what Title VI specifically prohibits. And I'll just read them through with you before going into a bit more detail. So denying an individual, these are the things that are prohibited when they are based on race, color, or national origin. It is denying an individual a disposition, service, or benefit, subjecting an individual to segregation or separate treatment, applying different admission, enrollment, or eligibility standards or requirements, denying participation as a member of a planning or advisory body, which is considered an integral part of the program, and also selecting a site or location with the purpose or effect of discriminating. So let's go through some examples here. An example of different services could be policing some neighborhoods and not others if they're based on race. An example of selecting a site or location with the purpose or effect of discriminating could be, for example, if there's an area with a large East Asian population, a drop-in shelter is built in a neighborhood far away from any neighborhood with a high concentration of East Asian residents. Meaning when there is a prominent minority in the community, there is a decision made to essentially deny that community convenience when a site is selected. We're going to move on to limited English proficiency. And again, this is limited English proficiency comes from national origin. So the protected class we're discussing when we talk about limited English proficiency is the national origin protected class. So the definition is for people who do not speak English as their primary language and their ability to read, write, speak, or understand English is limited. So as we mentioned, this flows from the national origin class. And a recipient of funds could employ a practice that appears neutral, for example, operating only in English, but it could affect people disproportionately based on national origin. So we'll spend some time on this. Since 1976, the Department of Justice regulations have included requirements regarding the provision of written language assistance for LEP persons. The DOJ has published guidance for recipients of DOJ funds, and this serves to clarify the responsibilities that recipients have. The significant thing to note here is that the recipient of federal funds needs to take reasonable steps to ensure meaningful access. Those are the key things that we focus on: reasonable steps and meaningful access. The Department of Justice has a 4-factor analysis, and we look at the number or proportion of LEP persons served, which is to say the frequency. It is part of numbers on their own, and then also the next component, which is the frequency with which the LEP individuals come into contact with the program. The nature and importance of the program. So for example, a 911 service would be considered more important than a annual community picnic, as an example. Again, not one thing is not going to determine the result, but these are all factors that are taken into consideration. Resources available to the recipient are taken into consideration because the LEP access needs to be free to the beneficiaries. So resources are looked at. And something to note here when we talk about the LEP individuals, we do consider distinct language groups. So we don't lump everyone who is LEP into one group. We will look at the number or proportion and frequency of contact for each distinct language group. So for instance, a recipient may have a large Spanish-speaking population and a large German-speaking population, but a very small Mandarin-speaking population. So when we're looking at an individual set of circumstances, we assess the needs of each language group and look at the needs of each group separately. There are 2 main components to language assistance. One is oral and one is written. In terms of oral language services, the recipient of federal funds must ensure interpreter competency. So while recipients may use bilingual staff or telephone interpretation lines, typically family members, friends, or uncertified coworkers are not appropriate. And often if you find that, particularly in the law enforcement context, you definitely want to stay away from a circumstance where the translator could have a conflict of interest in what the person who's trying to communicate wants to communicate to the organization. For written materials, recipients must translate vital documents if there's 5% of the service population or 1,000, whichever is less, if that is the LEP community. But there's a safe harbor provision that if that 5% is actually less than 50, then they just have to provide written notice that the individuals can get free written translation. Now to focus on what constitutes meaningful access. We're going to look at some hypothetical situations here. So the first is where during intake of a victim services program, an employee interviews a Spanish-speaking LEP victim of abuse using hand gestures and having the individual speak in broken English. The second is if the police officer attempts to question a victim of domestic violence by using the alleged abuser as an interpreter. So the question is, have these individuals been afforded meaningful access? And the answer is no. I hope it was readily apparent after the slides we went through. These are situations that we would definitely want to avoid. They would not count as meaningful access. So when a organization is drafting its LEP policy, there are 5 things that we are looking for. First is a process for identifying the people who need that language assistance. So a way to identify who is an LEP individual. Second, information about the available language assistance. So What language services will you provide and how? How do people access it? Thirdly, training for the staff of the funded organization. You want to make sure that staff know what the services are and how to access them. Fourthly, notice to the LEP persons themselves. So there needs to be a way for them to learn that these services are available. We want to see how the organization plans to let the LEP individuals know. And lastly, monitoring and updating the policy because populations are constantly shifting. And so an LEP population in a community 1 year might be different 10 years down the road. So we're looking for plans that can be updated. This is a quick overview, but actually LEP is something where there are a lot of resources available. One of the links that is given in this presentation on one of the end slides is www.lep.gov. It's a great resource. So that's independent of the Department of Justice information, but our website also has a great deal of LEP material. So there are lots of resources for you to get into this in depth. And we're now going to shift to, I apologize. We're going to shift to disability-related protections. We're going to focus specifically on Section 504 of the Rehabilitation Act of 1973, Title II of the Americans with Disabilities Act of 1990, and the American with Disabilities Act Amendment Act of 2008. So Section 504 prohibits recipients of federal funding from discriminating based on disability. Title II of the ADA also prohibits disability discrimination and applies to public entities. So that is regardless of whether or not they receive federal funding. And the ADA Amendment Act of 2008 restores the intent and protections of the ADA by ensuring consistency with Section 504. It's essentially another layer of protection for disability rights. For Section 504 specifically, this is the statutory language. And it focuses on, as you can see, a qualified individual with a disability. And focusing on the fact that it would be solely by reason of this individual's disability. Section 504 and Title II of the ADA define a person with a disability or disabilities as an individual who has a physical or mental impairment, which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. So it's an or. If any one of these are met, then that person meets the definition. It's important to keep in mind that whether a person meets this definition is a highly individualized and fact-specific inquiry. So physical impairments may be easy to think of, like a mobility, hearing, or vision impairment, but some physical impairments may not be readily apparent to an outside observer. A person with disabilities includes someone with a mental or psychological disorder, which includes certain learning disabilities, and some of those might not be apparent without testing or disclosure. The term which substantially limits is still a somewhat vague concept. Substantially limited is less than significantly restricted, but more than materially restricts. So the way to think about that, some factors to consider are the duration of the impairment, the impact of the impairment, and the nature and severity of the impairment. An impairment that is episodic or in remission is still considered a disability if it would substantially limit a major life activity when it is active. Focusing on what a major life activity is, Essentially, it's a basic activity that the average individual in the general population can perform with little to no difficulty. Statutory law now gives a list of examples of what are considered major life activities. Major life activities include caring for oneself, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, communicating, and also the operation of a major bodily function. So that includes functions of the immune, digestive, bowel, bladder, and neurological systems. Operation of a major bodily function also includes normal cell growth. So cancer is an example of substantially limited normal cell growth. I'm just going to wrap up this slide and then we'll take our break. I am aware of the time. In terms of having a record of such an impairment, what we're looking for here is that the person may have had a physical or mental impairment that substantially limits a major life activity in the past, but that they no longer do. So an example of this could be if a recipient knows that, meaning a recipient of federal funds, knows that an individual has received treatment for a mental illness in the past, and then they deny that person's services because of that. In that instance, the recipient has discriminated against the person because they have a record of having a disability. Similarly, if a job applicant was treated for ADHD in the past and then isn't hired because of this record of ADHD, then that recipient that denies this individual has engaged in impermissible disability discrimination. The last important thing to cover here is that the idea that impermissible disability discrimination is against a person who is regarded as, that phrase is regarded as, having a disability occurs when a recipient discriminates because of an actual or perceived impairment, whether or not the impairment limits or is perceived to limit a major life activity. So as you can see, the recipient's perception is significant here. ADA.gov, which is maintained by a component in DOJ, is an excellent resource, and it's another link that we list in this presentation. So it is there for you in the list of resources. There are many examples and further information on the topic. We'll go ahead and take our 10-minute break now. I want to make sure that we have enough time to go over the VAWA, Violence Against Women Act, implications in detail. So I am going to fly through these next few slides that may not apply to you here and focus on the ones that will likely apply, the ramifications of VAWA. As I stated, this entire presentation is available for you as a reference, and we are always happy to answer any questions. And also, these are very fact-specific analyses anyway, so this is more for your general information. We're going to move on here to our next slide. If the technology will cooperate. Okay. This gives examples of prohibited disability discrimination. The main thing to understand is that recipients of funding have to provide reasonable accommodations, and they have to provide those reasonable accommodations unless they can show there would be an undue hardship or it would fundamentally alter the service or activity. Hypothetical here that if a shelter for victims of violence receives federal funds and has a blanket policy that residents cannot take any prescribed psychotropic medications while staying at the shelter, this is not acceptable. The key here is that we're looking for individualized assessments. Section 504 requires recipients with 50 or more to take some further steps, as you see here. And there's help regarding disability discrimination concerns. Title IX has to do with sex discrimination in educational programs or activities. The Age Discrimination Act is concerned with age in any program or activity, and the specifications of Title VI. The Victims of Crime Act is also a significant non-discrimination provision spelled out here. And another thing I want to make sure to discuss are the equal employment opportunity plans. This falls under the work that the Office for Civil Rights does. We have a couple of core people who only do EEOP. To let you know whether this applies to you, generally it applies to everyone that gets money under the Safe Streets Act, except if there are less than 50 employees or the award is for less than 50, you're either exempt or need to report the requirements. What has to be prepared is a comprehensive plan. It essentially looks at the workforce, and the purpose is to eliminate underutilizations and dissemination plans. What EEOPs are looking for are numbers related to women and minority groups. These have to be submitted to our office, and it's within 120 days after the award date. These forms are due every year. Within 1 year for them to work with you at the outset rather than after something has already been started. So please don't feel shy in reaching out to them and connecting with them. I do want to make sure that we go over in detail the Violence Against Women Act. And here you'll note that the non-discrimination grant condition of VAWA applies to all grant programs that are currently administered by OVW. So that's significant for us here today. Examples of formula grants include the Stop Violence Against Women and Sexual Assault Services formula grant programs that will be excluded. So the significant thing to note here is in the program activity in whole or in part, also significant. And if any of you are state administering agencies, SAAs, that receive formula grants under VAWA and then sub-award those funds to sub-recipients, you might be wondering how the VAWA's non-discrimination grant condition applies to you. So it should provide training for sub-recipients about their civil rights obligations, and the SAAs should monitor their sub-recipients' compliance with the VAWA non-discrimination grant condition. So the takeaway here is that the SAA is on the hook, and so is the sub-recipient. Another question that often arises is whether there are any new data reporting requirements. Data reporting is actually something that the current administration is reviewing. but right now there are no, the VAWA does not create any new data reporting requirements. But OVW does require that its grantees and sub-grantees submit annual or semi-annual progress reports. So when a recipient receives funding to serve victims, OVW does require that these projects is a caveat to the prohibition on discrimination with sex, allows for sex segregation or sex-specific programming if it is necessary to the essential operation of a program. So in such circumstances, recipients may meet the VAWA non-discrimination grant condition by providing comparable services to individuals who cannot be provided with the sex segregated or sex specific. 13 version of VAWA will do a recap of the VAWA protected classes. We've seen many of these in the civil rights laws that we've already covered, but there are two new ones that do not apply to the other laws, and those are gender identity and sexual orientation. So to be clear on the definition of these terms, the term gender identity is defined for that definition. The VAWA non-discrimination grant condition borrows the definition of gender identity from the Shepherd-Bird Hate Crimes Prevention Act. So gender identity means actual or perceived gender-related characteristics. Gender identity is a person's internal view of their gender. So transgender in terms of sexual orientation, the VAWA non-discrimination does not define the term sexual orientation. Examples include heterosexual, homosexual, and bisexual. So this is just to emphasize that because VAWA had a reauthorization in 2013, the associated non-discrimination grant condition applies to all awards made under covered grants on or after that date. Specific programming is the bystander intervention component of some educational programs on college campuses. Often, these campus educational programs teach different violence prevention skills to male and female students. So how does a recipient determine whether sex-specific or sex-segregated programming is necessary to the essential operation of the program? That's that phrase of it being necessary. If the DOJ receives a complaint of sex discrimination based on a recipient's sex-segregated or sex-specific services, the onus will be on the recipient to clearly articulate why the sex segregation or sex-specific programming was necessary to the essential operations, best practices, which may apply, the just on unsupported assumptions or broad sex-based generalizations. So some factors that may be relevant to a recipient's evaluation of whether sex-segregated or sex-specific programming is necessary to the essential operations of the program include the nature of the service, the anticipated positive and negative consequences to all eligible beneficiaries. For example, to bring this point home, a recipient considering whether to sex segregate its housing should first assess the type and layout of the property where the housing is provided. Where victims must share bedrooms and bathrooms, that fact may be a significant consideration, supporting a determination that it is in fact necessary to the essential operation of the program to segregate those beneficiaries of the opposite sex by bedroom and bathroom, or depending on the circumstances, even to house beneficiaries of different sexes in entirely separate physical locations. In the case of a recipient that is considering their services specifically for sex-specific prevention education, if reliable research suggests that it is a best practice, that fact would likely be a significant consideration supporting a determination that the sex-specific programming is necessary to the essential operation of the program. For example, if research suggests that the bystander intervention model is more effective when it teaches different skills to male students and female students, that is a sex-specific manner. A recipient should not assume that because services have been sex segregated or sex specific in the past, that continued sex or sex specificity is necessary to its programming. So just because it was done before, it doesn't necessarily mean that it would be allowed to continue. The VAWA non-discrimination grant condition provides that when sex-segregated or sex-specific programming is necessary to the essential operation of a program, grantees may satisfy the non-discrimination prohibition by providing comparable services to be comparable, but they must be of the same or similar quality and duration. And again, as you've heard several times throughout this presentation, it is a fact-specific inquiry. So you have to look at the individual and the specific service. So the thing to remember is you are still screening for eligibility. You have to look at the service that you provide and consider the nature of the service, such as, does this service carry with it a particular need for privacy, such as sleeping quarters? Is there literature or evidence-based practices out there on the topic? And again, to not assume that just because services have been segregated in the past, that it's necessary. So remember, if there are sex-segregated services, they must be comparable. So that means that women-only services must be comparable to men-only services, and both of them must be comparable to integrated services. Comparable services are designed to confer a substantially equal benefit. Consider the nature and quality of services, therapeutic modality, location, characteristics of the facility, and characteristics of the service provider. One important thing to note here, because it sometimes comes up in discussions about providing comparable services, is that costs incurred in making services and programs free from discrimination are built into the costs of operating your organization. So that means there are no additional DOJ grant funds available for this purpose. As a brief refresher, gender identity is a person's internal view of their own gender, which may or may not correspond to the sex assigned at birth. Some tips in serving transgender clients: to ask the individual and not make assumptions. Consider their health and safety, and their own views, and to avoid isolating or segregating the individual, making burdensome demands for documentation, or asking about surgery or other medical interventions. Another specific topic, it's our last year level field when it comes to any community organization. An exception here is that typically organizations that receive federal funds cannot take religion into consideration when they hire, but for faith-based organizations, that is something that they may apply for an exemption. If they to avoid that the faith-based organization still cannot require a beneficiary to participate in religious exercises, and they can't deny a beneficiary access to their own religious services if they differ from the religion of the organization. This is a listing of some very helpful web resources for you that first is on our website. It's through the Office for Civil Rights. It's a video training that includes a PowerPoint. The other websites you see here, we discussed. The ADA.gov is great for disability discrimination concerns, and LEP for limited English proficiency. And also our office. Contact us anytime. We like to give out our general information because people, sometimes leave the office or are not in. So this is the best way to get in touch with us, whether you want to go through our website and to see what's involved in submitting a complaint, or to email us or call us. This is all of our information, and we are always happy to get in touch and discuss specifics. I know this was a lot of information today, and I thank you so much for your time and attention. And again, we're always happy to take questions and follow up on individual circumstances. And if anyone does want to have specific questions to send to Brianne, I will be sure to follow up on those individually. Thank you so much.
Thank you so much, Mona, for presenting and joining us today. I have collected the questions throughout today's presentation, and we'll make sure those get to you for follow-up. And thank you also to all of our interpreters today who joined us for today's session. Tomorrow is the next office-wide grantee orientation, so we encourage you to attend. It is on fraud. And if you need information about that, my email is bsmith@ncjscj.org, and I will put that in the chat as well. Thank you so much, and everyone have a wonderful day.
Thank you.